Yes.
Okay. Good afternoon, y'all. We're gonna do the CLE. If you guys have any questions, just feel free to post them in the chat box. Marla, we could go ahead and answer them while they ask. Are we on a particular slide or anything? I think that'll probably be best.
Okay.
Okay, so topic of the methodology I used in the practice of criminal defense is I call it the TTSTT mentality. It stands for take that shit to trial mentality. So I'll give you guys a breakdown of it. Today, the focus of it is going to be primarily on the investigation part and also some motion practice that I think can be helpful. I think the focus of any trial, any criminal case, even if you're going to plead your client out, should always be focusing on the final goal, which sometimes you have to prepare like you're going to trial, sometimes to get a good result. So let's start. As you guys know, you have a constitutional right to present a defense. And what I like to do in every case is, if I'm going to defend it, I try to constitutionalize my defense. So the United States Supreme Court actually said it in Crane versus Kentucky that a defendant has a right to present a meaningful and complete defense. So sometimes if you have a case where you're unsure about it, you have to figure out a way to constitutionalize your defense to advance your case. So sometimes you have to do that early on in the case through an investigation or even through motion practice. Louisiana Constitution is very specific on this issue. The Constitution itself speaks of our right to present a defense. So sometimes if you're in court or you have a prosecutor or a judge that's giving you trouble about a piece of evidence or a defense you want to raise, you have to figure out a creative way sometime to figure out how you're going to present that defense and get your client the best result possible. Recently in State versus Wilson, Louisiana Supreme Court case, the Supreme Court re-emphasized our right to present a defense. And it goes through the Chambers case and it goes through that and say that we have that right. So you have to figure that out. But how do we get there? I always tell people that I don't defend cases. I prosecute a defense, which is a little different from defending, because I think if you're going to defend a case, you start out the back end, you're trying to run away from something. I've been practicing law 13 years, going into my 14th year, and if you're trying to defend a case, you're going to have problems because you're trying to run away from it. I think you're going to have trouble if your only argument is reasonable doubt. I don't think jurors, in my experience, understand sometimes what that is. So if you're trying to defend your case, you're at disadvantage. So you have to figure out how you're going to prosecute your defense or tell your story of innocence, as I like to call it. So let's talk about how we develop our story of innocence. And to develop a story of innocence, you have to have a plan. Because if you don't have a plan, you're going to be in trouble. And sometimes, even if you have a plan, you have to be able to withstand that punch in the mouth that the prosecutor or the state or the opposing counsel, if you're doing a civil case or a family law case, they're going to attack that plan. So you have to be able to withstand that punch or that attack on your case. What I like to do in every criminal case, I don't do anything in my case if it doesn't advance my story of innocence and it doesn't help my client out. I won't ask a question just for the sake of asking a question, unless there's some end goal that I'm doing it for a reason. So I call that advancing my story of innocence, or even moving with a purpose. Even in court, when you're moving in court, it has to be with a purpose and it has to be meaningful. If it doesn't advance your story, you have to ask yourself, why are you doing it? Are you doing it to help your client? Or are you doing it for the sake of your own satisfaction, or just to show that you're an excellent cross-examiner, or you were able to catch the witness stumbling on in this questioning? So that's an issue that you have to make sure that you stay away from. So how do you develop your story of innocence? You have to brainstorm. Sometimes you have to get with other attorneys, get with other people to help you better understand your case. You also, something that we learned up in Wyoming, is called discovering the story. And that's kind of when you go through your entire case and you have people state out different ideas of what's the actual story of the case. Because people like stories. When we're defending a criminal case, jurors buy into a story. If you're just, all over the place and there's no concise story, sometimes you're going to have trouble in that case. After you discover the story, you have to come up with theories and themes. Your theory is just your overall theory of, your theory of defense, or your theory of your story of innocence. Your theme is kind of like a phrase line that you may say in a case, kind of like you remember the O.J. Simpson case. If it doesn't fit, you must acquit. Was kind of the theme in Johnny Cochran's closing arguments, and that kind of rang true. That's something that the theme sometimes is what the jury can bring back into the deliberation room and hang their hat on, that theme. Also, it's all about preparation. If you're not prepared and you're inexperienced, generally your anxiety is going to kick in. It's going to prevent you from doing your best for a client. The only way an attorney, us as young attorneys, and some are younger than others, is to be prepared. If you're prepared, your level of fear will go down because you're prepared for whatever's going to come up. I like to think of, there's 5 general defenses or stories of innocence that I've came up with, and some people may disagree, but I think generally your case is going to fall into one of these categories. You have some other dude did it. My client didn't do it, but we know some other dude did it, and we can point out to that guy. And there's some case law that you can present to say that you have a right to present that defense that some other dude did it. The next one is, I didn't do it. Your client didn't do it. You don't know who did it. You don't even know if it was done, but you're saying, I didn't do it. The next defense or story of innocence is, I did it, but I have a legal defense. And that's kind of when you get into, some of, it can be a self-defense claim, but it also could be like your compulsion claims, or, you had a legal prescription for it, or you had a reason for doing it, or, that goes into those legal defenses that they start about 1419 or 1420. You can look at some of those, and there may be others that case law has given us. Then there's number 4, I did it, but I acted in self-defense. And I think this is self-defense is also a legal defense, but to me, it's a little different than number 3. And self-defense, as a whole, is its own body of law. So that's, if your focus of your case is there, that's going to be a little different, because that's more factually involved. And sometimes you have to call witnesses to prove that point. And number 5, in my position, is the dude deserved to die. And this is a very complicated defense that you only can use in very limited instances. And that's a very case-specific and fact-specific defense. How you develop the theory of your case? This is a worksheet that I can give to Marla and share with you guys. This is generally what I use in our case, in every case that comes in my office. As we're preparing for trial, we go through this worksheet. We look at what's the theory of our case and our defense position. Why do we believe this is the best theory for our case? And you can have multiple theories early on in the case, but as you get evidence, conduct more investigation, sometimes those theories go out because just the nature of the evidence you have and the information you have. So you have to revisit this worksheet quite often during your preparation for the case. Number 3, which I think is one of the most important facts of any case, is the facts beyond change. And facts beyond change is facts that neither side can change. If there's a homicide, neither side can dispute that somebody died, or the facts that every side, no matter what happens, that both sides are going to have to agree to it, no matter what. So that this is very important, that you get to these facts and determine how best the facts beyond change apply to your case, how to take advantage of these facts. Number 4 was the best facts for you. There may be facts that's good for you, and the fact that's not good for you. The next thing is just listen, prosecution witness, what you want to get from each witness. How can you sometimes turn these witnesses that's on the other side to your witness? You may want to, it may be an issue of one small fact that's important to your defense that you want to get from this witness. Now, do you want to go through a whole cross-examination of this one witness for this one fact? Probably not. You probably want to get what you want to get out of a unfriendly witness and move on and leave that witness alone. Number 6, which we're going to a little bit later, is what further investigation do you need? What I find a lot is and I do this in my practice a lot, is that I conduct my own independent investigation. And I'll talk about that in a second. But what investigation at this point, what investigation has the state done? Or what investigation are you aware the state has done, and what you need to do further to advance your case? Number 7, you want to identify the evidentiary issues that you have early on in your case, and maybe attack those evidentiary issues through a motion in limine or some form of motion to help your defense and advance your story of innocence. So I talked about an investigation a second ago, but it's very important that in every criminal case, you investigate your own case independently. You don't want to simply rely upon what the evidence that the state has given you of saying that this is our investigation. I think it's malpractice, and is also ineffective assistance to your clients if you're relying solely on the discovery provided by the state. Because as we know, sometimes when you're defending these cases, the states, the detectives, the interviewing officers, they're not trying to figure out, what's helpful to your client. Now, there are some officers that do, but sometimes they're not trying to figure out what best helps your client. They're conducting an criminal investigation for a reason. In fact, the ABA standard says they actually have a rule on it that says you have a duty to investigate in all cases to determine whether or not there's sufficient factual basis for the criminal charges. And believe it or not, sometimes if you conduct a proper investigation early on in the case, you can have enough information to submit to the prosecutor or even discuss with the prosecutor to hopefully that they won't go forward with charges, or if they do go forward with charges, that they go forward with a lesser charge. And this is on the ABA website for criminal defense lawyers. There's some standards that they have, and you can find that there. I can get you the link later if anybody wants it. One important part of I think is important, is that going to the crime scene. You need to go to the crime scene yourself. If you can't go yourself, it's good to get an investigator that can go to the crime scene and assist you. Going to the crime scene is good for a number of reasons. You get to observe the crime scene from the vantage point of what it was, or similar to what happened on the day of the alleged crime. So that is important. And I'll give you an example right now of what I did in the case of going to the crime scene and how it saved my client from going to jail for 30 years on a drug case. So this is what I had in the report. This is a blurb from the report. The police officer said he drove to the intersection of Ann and Dale. He parked at the corner lot. In a parking lot, he observed my client turn from Cherokee Street to Eastdale without using a turn signal, and he was headed east on Dale Street. So this is all I had. Prosecutor offer was 30 years. My client had some prior offenses, and he was looking at going to jail for 30 years as an habitual offender. So what I did, I went to the corner of Dale and Ann, took a picture. And as I walked that scene, I noticed several things which was important. So this is the cross-examination of that officer. Asked the officer, you were parked in the parking lot of Dave's Quality Meats? I believe so, yes, sir. Next question was a setup question. You didn't have anything that can enhance your vision. Is that your testimony? No, sir. So this is when I'm in this parking lot, I observe across the street, there's these trees, these leaves, this fence. And way back here, if you can see it, is gonna be, this house. And on the other side of this house is the corner there. So next question, I go through it. I ask him, does he see, what does he see across the street from where he's parked? He asked me if he's referring to the trees. And then we go through an exchange about the trees and the leaves. And then I go further. Then I show him another picture of this intersection that is going to be pretty hard for him to see. So then my next question, I follow those questions up based on what I saw at the crime scene myself, that, is it your testimony that you had saw through those trees, through those leaves with your naked eye? And no matter what he said, he had to admit that he couldn't see the trees and through the leaves. So then I took a picture from the other side of the intersection, which would show that even from this angle, if he was at another parking lot, he wouldn't be able to see this intersection, because not only there's these trees and these leaves, there's also this house, which this corner kind of sits off of this street. So it would have been impossible for him to see that. And so had I not gone to the crime scene, I would never have known that, and I'd have been stuck with that report. So we'll go further, and I ask him more questions about, being able to see. He tries to give me some answers that not in this photo. And then I asked him about him being able to see through trees, and he had to agree. And a few questions later, prosecutor jumped up, dismissed my client's case, the co-defendant's case, and another young lady who's also charged in this case as a co-defendant. And had I not went to the scene, I would never have been able to help my client get this result in this case, because I wouldn't know the area, and it would have been virtually impossible to attack the state's case other than trying to attack it from the standpoint of, whether or not my client had the drugs, or whether or not my client, the cops violated my client's rights by stopping him illegally or illegally. So it would have been a question of, that would have been my only issues had I not went to this scene. Another important aspect of criminal defense work, your client. Your client has a wealth of information. Your client, but early on in the case, sometimes I hear this all the time that, well, my client lied to me. Well, we have to remember early on when we meet our clients for the first time, early on in the case, they don't really know us. They aren't comfortable with us. And there's this stranger who has their life in their hands, and they are concerned whether or not, there's this question of whether you're going to do what's best for them. So we have to talk to our clients. We need to interview them early on, as early as we can, to get as much information to assist in our investigation of where we need to go. We also have to listen to our clients. Generally, when I meet a client for the first time, I don't even bring a notepad. I just kind of want to hear my client out. I want him to understand that I'm listening to him, that what he's saying is important, and he's going to be heard. So I don't listen to your client is something that you have to do, and it creates a bond. If a person feels like they're being heard and somebody's there to try to understand them, you build a relationship that can help you later on. And you have to do multiple interviews. I know it's hard sometimes. We have a ton of cases of meeting with every client, but it's really important that you do meet with your clients on multiple times to understand their story. And also, sometimes your client may have left something out. Sometimes they may have forgotten something. As you conduct your investigation and you receive discovery or you receive new information, it's good to review that information with your client, because sometimes your client is the only person that can tell you whether or not that's true and what steps you should take next, or what does he believe is important as to next. So that's important. And the last thing, I think I talked on it earlier, is just building that trust relationship, because at the end of the day, if you have to go to trial on the case, that client's life is going to be in your hand. So it's really important that he or she trusts you, that you're going to do what's best for him as you try to get justice for him. The witnesses. We got to look at these witnesses, and that's part of your investigation. Sometime in a police report, you'll get names of several witnesses, and it's important that you learn as much about these witnesses as possible. And where do we find that information at? We live in a day and age of the digital age. You can find a wealth of information about a person on social media and Google. I'd suggest every case you get, you try to do a background check on them, even if you have to go to your local clerk's office to run that person's name in the computer to see if there's been any criminal arrests, or even if there's been any criminal charges. I always say I like to get the information. I'll figure out how to get it in evidence later. Give me the information first, and I'll figure out how I need to get it in evidence later. So sometimes, generally you can't get a person's arrest in, but it may be important for another reason later. Google their name, see what comes up. Facebook, Twitter, YouTube, Instagram. There's always information there. In this day and age, especially with a lot of younger people, if you have some young witnesses in your case, I would say 9 times out of 10, they're probably going to talk about their case on Facebook, Instagram, YouTube, maybe Snapchat. I don't really know how to use Snapchat that well, but that's information that you need, and it may advance your defense or your story of innocence later. So I would just get it and just keep it there and use it as it becomes available, or use it as it becomes applicable to your case. So I give you another example of where I used, through my investigation, I used the search of an individual who was a witness against my client, his Facebook page, his Instagram page. So his name, it was an armed robbery case, and his name was on Instagram and Facebook was Goonie KJ. And, so we all know what a goon is. And he had some issues of defining what a goon is. He said it meant nothing, but I asked him if he had a Facebook page. Fresh out of the gate, he denies having a Facebook page or Instagram page, and that he went by the name of Goonie KJ. So while I'm going through his testimony with him in front of the jury, I asked him about this question, and then I show him this. This is you. At this point, he has no choice but to acknowledge that this is him. And this is his Facebook page, and that he goes by the nickname of Goonie KJ, at least on Facebook. My next question that I learned from watching Facebook is that this young man had a lot of guns. He had access to a lot of guns. So he had testified on direct that, and when he initially was interviewed by police, that he didn't play with guns. He didn't own any guns. He never had touched a gun. So through my investigation of his Facebook page, just searching his name, I get this. I have this young man with a very scary looking assault rifle and also a pretty big handgun in his pocket. So he denied it, but that attacked his credibility. And had I not went on his Facebook page and searched that, I'd have never had that information. The last thing that I did with him, I also had somehow or another found out that he was a member of a rap group or some kind of local gang. And he was testifying against my client, saying that my client was the armed robber of a case and he didn't know anything about it. And he had no involvement, but it was my client. Well, I found this on YouTube where he was a member of a rap group, and they talked about robbing people, killing people, and using guns. So I asked him about the rap group. He said he wasn't a member. And then I asked him if he was in a video. He says, yeah, but he tried to wiggle out of it. And then I asked him about being affiliated, talking about killing and robbing people. Well, he of course he denied all of that, but then I was able to show the jury that this is him. Got him, walking the street, a bunch of money, and a rap video called Homicide. And in this case, some young men went to a town and got robbed, and some of them had got shot. So it was important to show the jury that this young man had rapped about all that stuff. Now, whether it was true or not, that was for the jury to decide, but it was my position it was true because it advanced my client's case, that my client wasn't even a friend with this guy, and he may have been protecting some of his other friends who's a member of his gang or his rap group. Another wealth of information when you're conducting an investigation is the Clerk of Court. You can get a ton of information there just by going there and searching a person's name. I always suggest that you not only search the criminal records, but you also search the civil records. There's nothing like having an angry, spouse, an angry girlfriend, who files, a restraining order or files a lawsuit or files some kind of petition, or even, there's some civil case where, challenging your credibility, saying you committed fraud of some kind. So I start at the clerk's office. I go there and I conduct my own research, and that's always part of my investigation. So in this case, I'll give you another example of it. In this case, my client was charged with manslaughter, and a young man had ran into the back of his car, and the young man left the scene of the accident, and my client followed him, and the young man ended up dying as a result of my client following him. The state charged my client with manslaughter, saying that the young man fled the scene because my client had a gun and my client had made threats against him, and that my client chased him ultimately to his death. Well, in this case, this young man was from northern Louisiana. He had no connection to South Louisiana, and throughout the case, I was just confused about why this young man ran, and I couldn't understand it until I made a decision that I would call the clerk's office in northern Louisiana to find out about this young man. And when I called one clerk's office, I found out that this young man had a failure to appear warrant. In this case that I'm talking about right here was in 2017, but he had a warrant from 2015 that this one court had issued. And then when I called another parish where I found out he had also had some connections to, he had another warrant. So basically, this young man had two warrants for well over 4 years. So that became my story of innocence, that this young man was not running for my client, or he wasn't running for my client because my client had did anything, but he was running because he had these warrants, because he knew that if the police came, that, he was going to jail, do not pass, go directly to jail, and he was going to get some jail time. So he ran for my client. That became our story of innocence. And in this case, my client, who was facing 40 years on a manslaughter, if he got convicted of manslaughter, the jury ultimately came back with a responsive verdict of guilty of negligent homicide, and my client ultimately got probation, as opposed to a pretty significant sentence of on manslaughter if he would have got sentenced for the 40 years. Creative motion practice. This is something that's in every case. There's different schools of thoughts on it. Some attorneys think that, pretrial motions are a waste of time, that, if they file stock pretrial motions that maybe they got from an older attorney or somebody told them that was a good motion. It's my position that I have very few stock motions in my office. In our office, we have a standard discovery motion that we file in every case, maybe a standard preliminary examination motion, maybe a standard motion of continuance. But outside of that, every motion that we have is generally, case specific. And sometimes you have to get creative on these motions to kind of get the result you want, or get the piece of evidence you want, or even just to get a hearing to maybe show the state that this case isn't as strong as you think it is, or there's some evidence that you haven't considered that, a judge may hear it and, may make some rulings that may make the states think that, hey, maybe we should offer a better plea offer in this case, as opposed to, going all the way with this case. So my goal is, a lot of times in these cases, and I do a lot of homicide cases, so sometimes once, if we don't file a preliminary examination early on, or bound reduction, we have, in the case goes to grand jury, sometimes our ability to have a contradictory hearing on a preliminary examination is real limited if we get the case after the case has been indicted. So sometimes you have to figure out, how can you get a contradictory hearing, or sometimes you file a motion to limit hearing with some evidence that you want to get in that you think the state's going to object to. Is my position that you always want to have those rulings early on, so that way you can take a writ, or you can appeal those issues pre-trial, as opposed to waiting till trial and the state objects. And if your whole defense was based on a piece of evidence that may be objectionable, and if the judge doesn't rule in your favor, now you're stuck and you're having a trial that, you can't get this piece of evidence in. Then you have to hope that if your client gets convicted, the appellate court overturns your client's conviction and gives you a new trial. And as we know, sometimes when you go up farther the ladder in courts, as you go to appellate courts, the standard of review is a lot different, and it's harder to get a conviction overturned sometime on an evidentiary issue, because you get stuck with the harmless error, because the court's going to look at it and say whether or not an error is harmless. And it's always my position that no error is harmless. We're the only industry or only profession that I think an error could be harmless in. So you want to try to litigate those motions early on in the motion in limine to avoid, not being able to bring that stuff up in trial. So I'll give you an example of a creative motion that we came up with. In this case, I had a piece of evidence that I didn't know if I was going to be able to get in. This was the facts, and it was a very serious case, and my client was facing life in jail. But he had told me that this young lady had attempted, his girlfriend had attempted to stab him before, and he was the only one that knew about it, and that it would be difficult for us to get this evidence in. And then we got some cell phone records that kind of supported his position that he had been stabbed before or attacked by this young lady before. So we filed a motion in limine to have a pretrial hearing to get the court to determine whether or not we could bring this prior violent act that this young lady had committed against him in. And basically, I would say when you're filing motions and you're not filing stock motions, you want kind of your titles to be attention grabbers. So in this case, we filed a memorandum in support of the motion to introduce the prior knife attack committed by Bria Baptiste to show Donovan Kennedy's state of mind. So that was important that, that's kind of not a stock heading. So when that goes in and the judge or the judge's law clerks read that, to me, if I just would have had motion in limine or memorandum in support of the motion in limine, that's not an attention grabber. So you kind of want to grab the court's attention that, hey, this is something serious. This has some teeth to it, and this is important, or they wouldn't be filing this. Then that's why that's another reason why you want to kind of stay away from just filing stock motions. If you don't have a motion to suppress issue, or a motion to suppress of a traffic stop, or a motion to suppress of a statement, you don't want to just file that when you file your motions, like a motion to suppress. Some lawyers do that, but to me, you lack credibility with the judges when you do that kind of stuff, because you're just filing motions and then you continue it or then you withdraw it. When you have a legitimate motion, some people, my position is that if you have a legitimate motion, if you've been filing all these stock motions, these meaningless motions that have no bite to it, judges may not pay attention to it as much as something when you only file motions that's relevant to your case. So that goes with not just filing stock motions and filing stuff that's applicable to your case that you actually have to litigate. So in this case, once again, I went to the scene of the crime and I observed the crime scene myself, and it helped me with my cross-examination of the witnesses in this case, and to help me understand what my client was perceiving that night and also what the witnesses would say. So in this case, at the motion hearing, on our motion to get the prior knife attack in, the state called the sister of the young lady that had passed away, and I was able to ask her questions. So, at that point, Bria became upset? Yes. And after that, Bria became upset. She went to the kitchen and got a knife? Yes. And she took her cell phone? Yes. And, then she called Donovan, he came back. So we go to this slide and, I have a crime scene photo that has the knife. So I know that's the reason why the knife is in the street. But before we move on, I think Marla may invite me, hit Marla later for cross-examination. This is a cross-examination which I learned by going to this conference, 2 weeks conference in Macon, Georgia. It's called the One Fact Per Question cross-examination. And you don't really learn this in law school. It's you add one new fact per question. That way you tie the witness down to answering your questions and not being able to wiggle out of it. Because I could have easily put, she went to the knife, she got her knife, she got her cell phone, and she was upset in the one question. But if she said yes to that one question, she could easily say, well, I said yes to her being upset, but not the knife and the cell phone, which will be pretty important later on in my cross-examination. So next questions was, she left out of the house with the knife, the cell phone, right? Because I've already had that's all facts. So I can add facts to questions if I've already got her to agree to it, and she was upset. So when I went to the crime scene, there was a mailbox immediately by this young lady's house, and in this crime scene photo, without going to the scene, this photo means nothing to me because I don't know what this is. I can see there's a cell phone and maybe some kind of keychain or some kind of ribbon or something, but it means nothing to me without going to the scene to actually physically see it. So my next questions, was just going through it, asking her, about the knife. So in this case, we have a knife in the street. We know Bria went out of the house with the knife, and she was upset when she called my client to come back. So at this point, there's a knife in the street. So I have to tie her down to admit that she didn't touch the knife, and no, she didn't see anyone else with that knife, because that only way that advances my client's case, because the state could easily argue that they don't know how the knife got in the street, or maybe my client had the knife, or what have you. So we had to tie her down that Bria went out the knife, but she wouldn't admit that Bria had the knife in the street, because it was important to my client's defense that he acted in self-defense, because farther down the street, you have a knife in the middle of the street, and you have back here, if you can see it, you have my client's gun. Well, the state wouldn't acknowledge that, Bria went in the street with the knife. None of the witnesses would, but they couldn't explain how this knife got down the street. So I had to tie her down to these facts that this knife was in the street. She didn't see anyone else with the knife but Bria, and that neither her or her boyfriend or anyone else had touched the knife in the street that night. So just further cross-examination, just asking her about the knife, and that Bria armed herself with a knife and she went out the house with it, and also that she don't know what happened with the knife after Bria went outside the witness. And I left her alone because she was a dangerous witness for me, and I didn't want her to break down on the stand and make this more of an emotional case than what it was, because she could have easily, went into something else, and then all this hard work that I had got to show that, her sister helped assisting me in proving that her sister was the initial aggressor in all of this, and that her sister had committed an overt act that would have allowed me to get the prior attack in against my client. I needed to do all this, and so I ended the questioning after I got all that from her. I probably could ask her a ton of more questions, but it would have been dangerous for me, and it wouldn't have been productive for me had I went further with my questioning outside of what I wanted from her. I had looked at my theories and theme sheet. I had her listed as a witness, and I had identified what I wanted to get from this witness, and I didn't go further than I should have, because my cross-examination could have ran astray, or could have not been as productive as it was. And just to show you this method worked, my client was charged with first-degree murder, I believe, or second-degree murder, and he also was charged with attempted. The jury came back with, on the murder, negligent homicide, because the gun that went off during a struggle, and my client, the young lady, passed away. As to the sister that you just saw at cross-examination, the jury came back not guilty on the attempted murder as to her. So, I don't do this to toot my own horn. I'm just showing you that this method that I'm telling you, this method works. I'm not the only one used it. I've showed it to several other attorneys. There's at least 4 other attorneys in my office that uses it, and it's work. It works. And I'm not telling you this is the only way to do it, but this is a good way that I've learned of combining several different methods that I've learned from Wyoming, from Macon, Georgia, from California, from Louisiana, that helps you advance your case in your story of innocence. The next thing is, we all get this open file discovery, and it goes into investigation as to, once you've conducted your investigation, the prosecutors give you open file discovery, you review the file, but you still think there's some things missing. And if you can identify who has those items of evidence that you need, one vehicle to kind of get that information is to file a subpoena duces tecum. The Code of Criminal Procedure allows you to file subpoena duces tecums on different individuals, on different agencies. Sometimes maybe the arresting agency, there may be some rules against not allowing you to do it, but you have to figure out how you can, what vehicle can help you still get this information that you know that's out there, but you just can't get. So the subpoena duces tecum is a one good one, and you file it with the clerk. Clerk sends it to them, and sometimes they'll send the information directly to you. Sometimes they'll send the information to the court, and then the judge makes a decision whether or not you should get it. Or sometimes they'll send the information to the state, and then the state may file a motion to quash, which, in my opinion, the state doesn't have any standing to file a motion to quash on a subpoena that I've served on an individual or agency that has information. That individual or agency has to file a motion to quash my subpoena duces tecum, but that's a little more, I guess, not the purpose of this hearing. It's just an idea of what's available to you. And this is an example of a motion, a subpoena duces tecum. I served this on Iberia Parish probation and parole, and I requested several items that was in their possession as to a person that they were supervising. In those documents, and I just did this a couple of months ago. There was a wealth of information that, had I known in other cases where I had people that were on probation that was testifying against my client, if that was available, I probably would have been filing them a lot sooner. But I have got a wealth of information where the guy actually was talking about, what he expected, to get in return for, providing information against my client. So I have all that, and that's going to assist me in my cross-examination, because now I can go through, you told your probation officer X, or, you wasn't seeing your probation officer because you told them, you were a witness in the case and you didn't think you had to appear anymore. So there's a wealth of information that's going to assist me in my cross-examination, and also my overall theory or theme for my case in advancing my story of innocence. The next vehicle you can use if it's available, sometimes is a public records request or Freedom of Information Act. You file those, you just simply mail those off or fax and to an agency, if it's a state agency or a governmental agency. You file that over and you request your specific information. And in fact, they can't even ask you why you want it. If they call and ask you why you want it, or they don't comply within certain days, there's remedies that you can, get attorney's fees and also costs, and get the court to demand that they present it to you. And we've dealt with that issue several times where we've requested information, and we actually, in one case, we actually have a judgment against a district attorney's office for not complying with our public records request timely, because they didn't think it was subject to the public records law. And this is just a simple public records request. Just you do this by mail, and I do it by mail and fax, just to verify that they received it. And I just list the items that I want. And you could do this early on in the case if you can't get an arrest affidavit or like some information about why your client was arrested. This is also sometimes a good tool to use to get information as to, what's going on with your client's case, to get a copy of the initial reports, because sometimes some parishes, initial reports are hard to get because some prosecutors just don't want you to have them early on in the case. Another vehicle is that I like to do is sometimes, I'll file a public records request or a subpoena duces tecum for a policy and procedure manual for an arresting agency or the state police, or or some training. So if it's a case where you're trying to attack something the officer did, you want to know what their policy is as to that specific aspect of your case or their actions. So sometimes if you're challenging how they should conduct the use of force, or how they should execute their reports, or what's required. You learn that stuff from looking at their policy procedure manuals. Like, so most agencies locally have a rule that if somebody arrests somebody, they have to complete their reports within 7 days. And sometime an officer, you get a case where you have a hearing early on, and you tie the officer down to certain things in that report, and then lo and behold, months later, some magical report appears, and so then you're stuck with a new report that kind of defeats, your overall defense. So you kind of want to know that agency's, policy procedure manual. So, that report may still come in, but you want to be able to attack it and say, well, this is your policy at your office. Isn't it true? And, he has to acknowledge it. He has to acknowledge as an officer are a member of that agency, that's the rule, because they get those policy procedure manuals when they're hired. So, and also sometimes there's a wealth of information in officers' personnel files. You could do a public records request on officers' personnel files. Sometimes there are disciplinary issues in that file. You can request it from a prior agency if you think an officer is, if all of his reports look the same and they seem the same, and you think there's something just not right with it, you can go ahead and request that the disciplinary part of that officer's file. Sometimes you'll get a motion. They might file a motion to quash and say that you're asking for something that's protected or confidential. But generally, what you ask for, you say, you could take all the Social Security numbers out. You can take his closest relatives information out. All I want is his disciplinary files. Or sometimes you may want to find out what this officer was trained on. If you think some part of the case they didn't investigate it properly or wasn't handled properly, it'll assist you in your cross-examination. If you're saying, okay, well, officer, you were trained on, how to interview suspects, and part of your training is that you don't question multiple people in a room together because you want to get that person's story. Or if you're challenging the ID, the policy of showing a lineup is this, officer, would you agree? And if he denies it, you show him the rule. You say, this is your policy procedure. Can you agree this is the rule? And that will help you in your cross-examination or your case presentation of, ultimately telling your client's story of innocence. But this is just a use of force. Something I got out of the policy procedure manual was the agency's use of force. And I used this in a homicide case that I was defending, and I made the officer my expert by saying, officer, you understand that there's a continuum of force that an officer is supposed to use when determining whether or not to use legal force, because the state was saying that my client didn't act in self-defense, and that my client had went too far, and that my client may have shot the guy 8 times, and that that it wasn't self-defense because 8 shots wasn't self-defense. So I was able to question the officers in this case about the use of force continuum that I had got out of state police manual. Now, it wasn't specific to that agency, but this officer had to agree that with most of these things that this is when you have to use deadly force when it rises to this level. And I used that to assist me in cross-examining this officer. And we're almost done. I don't know, Marla, do we have any questions? We got about 11 minutes left, I believe.
Yes, we do have one question. Are there any books, resources, or other materials you suggest to read to learn criminal trial practice?
I think the best thing that I do, and I still do to this day, there's a lady out of New Orleans. She puts out a monthly newsletter called Louisiana Supreme Court Reporters. And she reports basically on all the cases that the Supreme Court hears that during that month. And she puts a little blurb of what happened in that case. And a lot of times that, it may not be relevant to your case right then, but if you read it, the issue comes up, you say, okay, well, I remember I saw that issue in that Reporters, and I have a little folder in my computer that I put all those weekly newsletters, and I title it as such. That way, if I'm looking for that issue, I can just go search my computer and that issue will come up. So there's that. There's also, I would say, if you're practicing criminal defense, you want to join Louisiana Criminal Association for Criminal Defense Lawyers. We have a listserv. I'm the former president of it. We have a listserv that I think is invaluable. If you have a question, there's at least 500 members. So if you have a question about a criminal law issue and you post that question on our listserv, somebody's going to be able to help you with it. Somebody may even be able to give you a motion, or you may be able to somebody may say, call me, or you may be in the middle of a trial and you can't think of an issue. So I think that's also a valuable resource that you have to take advantage of. As far as books, there's a Louisiana Criminal Practice Handbook. I think if you're doing criminal work, whether you're a prosecutor or a criminal defense lawyer, you should have that. It's kind of like from start to finish. It takes you through the pre-trial phase all the way to trial. It gives you, I guess, a framework of what you should be working in, and it has some research in there, so that may be a good starting point of your research. other than that, I think, there's a ton of books, out there. You just kind of, I read a lot of Jerry Spence stuff. Uh, and I went to his college, and that's where I read a lot of his stuff. I'm also on staff there. So, but, I would say anything that can help you. I look at it, I'm always looking for information and ideas in my criminal cases, so I may be at church and, the pastor may say something that I think is important I could use in the case. I might write it down, and use it later in the case if I think, it resonates with somebody. But I think, you got to read a lot of these case laws and just the criminal procedures. If you look at the annotations and the notes and decisions, just on a specific, I guess, statute or crime, there's like a bunch of cases in there that can probably point you in the right direction. So I don't know if that answers your question, but that's kind of why I think I started at. That's the only question we have right now, Marla?
Yes, that was the, or no, how often do you hire an investigator?
I would say I hire an investigator more often than not. I do a lot of homicide cases and violent crime cases where there's witnesses that need to be interviewed. So more often than not, I hire an investigator. I think it's just a safe way to play it. Sometimes, there may be certain tasks that I may not get the investigator to do because I want to go look at the crime scene myself. Now I may, if it's some pictures or something, I'll take my own pictures sometime at a crime scene. I'll get the, investigating officer that acknowledge that this is, where the incident happened at. But I think you have to play it safe. And also sometimes, if you get a call from, client's girlfriend or client's, somebody, family member says, well, I know I made that report, but I want to talk to you and I want to drop charges. I think ethically, what I like to do is just get an investigator to talk to them, because I don't want to talk to that witness necessarily myself, because, sometime in court, that witness may say, well, I didn't, he called me or he told me I should, the attorney, I've saw it all the time, the attorney told me I should drop the charges. So you want to kind of keep yourself from, that kind of trouble or those kind of problems. So I hire an investigator to go out and get those statements. So I would say about 75% of my cases, I get investigators, to do certain aspects of the case.
We have a follow-up question. Well, not really a follow-up, but another question. What case law should every criminal lawyer know?
The first three slides, you have a right to present a defense. That's the Constitution, both the United States and the state, that, even if the judge doesn't agree with your defense, even if the prosecutor thinks your defense is silly, or, and if you have some piece of tangible evidence, whether it's testimony only from even if it's only testimony from your client, you have a right to present that defense. They can't tie you down and say, well, you can't present that, because you don't have any evidence. But if it's a valid defense and you have some kind of evidence to assert that defense, that's, to me, that's the most important thing is, you want to always, the Constitution, I would say, as it applies to criminal work. So you want to know Louisiana Constitution, because our Constitution gives us a lot of rights when you come to criminal defendants. So you want to be able to constitutionalize your defense and say, well, Judge, I hear what you're saying, but, I got a right to present a defense. And early on, when I was showing that the guy had those warrants in those other parishes, actually, we were picking a jury, and the judge said I couldn't get those prior. I couldn't get in the fact that the guy that passed away had warrants from those other parishes. And I made the argument that I had a right to present a defense. The judge ruled against me, and I took a writ to the Third Circuit, and we're picking a jury. I'm typing the writ up as the jury's coming in, because the state filed this last minute motion and he granted it that wanted to prevent me from, talking about our reasons why we believe the young man ran, as opposed to the reasons why the state ran. And the Third Circuit ultimately ruled that we could use that information because we had a right to present our defense. And the jury had a right to consider all different facts and possibilities, and the state had to, prove beyond a reasonable doubt that that wasn't a reason why. So, being able to constitutionalize your defense, I think that's some of the most important case law that you can find, and figure out how do you do that.
We have another question. Do you have any tips on crafting direct and cross-examination questions?
I think, I got a lot of tips on that, Marla. I can give you a nutshell. Cross-examination, Marla wants to invite me again for another CLE. I can, show you how we do cross-examination. We've learned from, there's a book called Posner and Dodd. I think it's called the Science of Cross-Examination that Posner and Dodd put out. It's a real expensive book, but we basically in cross-examination and direct examination, I use what's called the chapter method. So when I'm starting a question out with a witness, whether it's direct or cross, I'm going to say, well, Mrs. Dixon, I want to talk to you right now about the CLE that we're having today. So I'm bringing the jury's attention and also the witness's attention into that chapter of it. So, and when I move on, I'll say, okay, now next I want to talk to you about this. So it's like kind of like reading a book, because we think in stories, throughout, I guess, history or the beginning of time, stories was all the thing that everybody can follow. So if you're using a chapter-based method, whether it's direct or cross-examination, I think you're in a good place. Direct examination, I think, is about the witness. The witness that you call is about their story. On cross-examination, I'm a little different. The story is about my story and what I want the jury to know. I may question a witness, and I may not care what the witness. I may not care if the witness says yes or no, because I'm telling my story and I have something to support that. So I think that's important, that you have to prepare, and you have to like write it out. I generally write all my cross examinations out, or early on I used to write all my cross examinations out, like step by step. But you don't want to get stuck with the paper. You don't want to be focused on the paper. But even if you write it out, you kind of want to be able to, move around and not just be bound because you wrote in your legal pad, this order. Sometimes the order of questions just based on what the witness gave you on direct examination. When you're crossing him, you may want to start at a different chapter, or you may not want to question on a particular chapter or questions about it. So I would say cross-examination is kind of about adjusting and making adjustments, and I'll talk about that briefly in a second. But you have to, I guess, figure out what you want from each witness, and that's kind of goes back to, I think, early on when I had the theories and theme worksheet. You want to identify each witness, and you also want to identify what you want from each witness, whether that witness is going to be on cross or on direct examination, because you have to have different kind of questions for each. Because on cross, you can pretty much lead them. On direct, they got to kind of tell a story. So that's kind of what you're stuck with.
And thank you for volunteering. You will be back many times.
Oh, I got. Let me see. I got. Well, I'll skip to my last slide.
But we have one other question, if you wanted to take that one too.
Okay.
Do you teach or does your firm offer classes that are for pay?
Yeah, we actually right now, early on, I think the title of it was TTSTT. We actually working on. We actually developed some of our own stuff. We're going to start teaching real soon. It's probably going to be for free till we get a big enough following. On what we're going to do. So I just kind of trademarked that name and kind of trademarked the whole TSTT. So you guys can be on the lookout. And even if somebody just has a question, they're welcome to send me an email or give me a call to ask, about, the question. I'm always generally available. If you call early in the morning, and I wake up at 5 o'clock in the morning, I'm working out. So if you got a question, or if you want to call late at night, we're generally working, or we do our best to answer. And if I can't answer it, hopefully I can, maybe point you in the right direction of who should be answering it for you. Anything else? And I guess the last thing, that was the last question. I think this what I want kind of everybody to focus on that's on this Zoom, this Zoom call or this Zoom meeting, is that you never want to give up. It's a daily fight, and that we do difficult work, and you just can't give up. My mentor Jim Boring told me early on, his war cry is, quit or get better. So none of us are quitters, because we're either in law school or we're practicing attorney, so we don't want to give up. So you just got to keep trying to get better. So never give up, and just keep trying to get better. And that's all I have, unless anybody have any other questions before we get off.
Okay, does anyone have any questions? Any remaining questions? We have people thanking you that this was awesome, and I want to thank you on behalf of the CLE department and SULC for sharing your knowledge and wisdom with us today. Harry will be back on December 7th for the end of the year CLE. And you can also, okay, we have one other question. Is there a website for us to get information regarding those classes you just spoke about?
I'll put my email address up there. You can just email us about it. We're probably going to start early, sometime in January. We're still kind of getting off the ground. COVID kind of helped us, get our stuff together because we have been kicking the ideas around for a while. But COVID kind of helped us slow the world down enough for us to do it. So if they just send me an email, we'll give them some information about, when we're going to start doing the presentations and the classes to help everybody out.
I'm about to copy and send the email address to all the attendees. So you can write down his email address, but also I will send it out to everyone in the follow-up email with the recording and also the PowerPoint slide. Got it. Start recording. So